rings on the computer.
All right.
A number of different ways I can disrupt the meeting.
Going to go ahead and open up the meeting. Welcome to the special committee for the Division of Children, Youth, and Families. Would you please stand and join me in the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Good morning. A couple of housekeeping items. If you are testifying and you have written testimony, if you could please hand that up to the clerk before you start speaking. And if you wish to submit written testimony online, you may do so by emailing the committee. And we have our own email address even, which I will give to you. Oh, I'll pull it up after and tell you. I've also reached out to IT and House Committee Services, and they're going to help us make sure that you can submit testimony online on the online submission form. Right now, you have to put in a bill number, so the form isn't working for on our committee webpage, so we're going to work on fixing that. And that being said, if you have documents that contain sensitive information, you're expected to self-redact any information that you might have court orders not to share, or personal information that you wouldn't want to become part of the public record. Our topic of today is due process. Where did it come from? What is it? When is it required? Are there different kinds of it? What are the essential elements of it? So I see we have a number of guests here who may inform us of their understanding of due process, and members of the committee also have their expertise to share on that. And perhaps there are some stories from people in the audience about their experiences with due process as it relates to DCYF. And then afterward, the committee will have an opportunity for discussion. Our committee researcher was kind enough to provide us with some documents. And so there were a lot of them, and that would have been a lot of paper. So if there's anything that you all want printed for us to have here for our discussion after specifically, we can let Christina know if you want to, we can just ask her and then we can get those printed. Right. Okay, so I think I will start with calling the first witness. Didn't even look through these, sorry. So I think I'll go ahead and call first witness is Joshua Peruse.
Madam Chair, any point of order?
Yes.
Pursuant to RSA 1414, which states any senator or representative, while acting as a member of a committee of the legislature, may administer an oath to any person who may be examined before such committee. I would like to require an oath of the witness and all witnesses testifying before this committee. The testimony we are taking is concerning very serious subject matter, and we must ensure truthfulness. There have been various committees, both ad hoc and standing, which have heard lots of testimony relative to family law matters, and in many cases can go on and take up lots of precious time. And sometimes it was later found out that testimony was infactual. What we want to do is establish that this process is eliciting factual information so we can make the most informed decisions based on the testimony we receive.
Well, I've looked up that RSA myself, and it is I'll allow it. The point taken. I think it's very prudent. Representative Weber, did you have a point of order?
Yes, it's something that we normally do not do, and this is not a tribunal. This is a fact-finding mission, and it seems to me that to require an oath is way outside of our normal procedure. And as one who assumes people standing in front of us are going to be truthful, I think it's frankly kind of insulting to our witnesses. But I also, the point of this committee is to discover issues with DCYF. It is not to prepare the ground for some kind of for future prosecution. And so I think that the administration of an oath is both unnecessary and insulting, and I would really prefer to get a ruling from the Speaker's office as to whether it's an appropriate thing for us to be doing, because I've literally in 18 years never seen it.
Okay. I appreciate your thoughts. I'm going to go forward and permit the oath to be performed upon the witness.
I'm going to object until we have a ruling from the Speaker's office. You can take a vote.
Actually, if I can comment.
Yep, go ahead.
Thank you, Madam Chair. So a lot of people that testify, in my experience, are under the perception that they were wrong. There are often times when their perception was changed and they didn't go through the right people. The fact that people are showing up here, taking their time out of their day to show up here, I trust. I do peel the onion to see where something may not be the reality, but it's their reality, and I absolutely agree that it's their reality. So to put them under oath, I think would harm that.
Okay.
Because if we find out later that it wasn't the fact, but it's their perception and their fact, that may be problematic. So.
Before I hear your thoughts, Representative, I'm going to share my own. I think that it's good form to expect truthfulness in our testimonies that we receive here, and we can't make any decisions if we're receiving any information that is frivolous, unnecessary, or untruthful. Of course, you can't verify that the information that you're receiving is truthful without an oath. So this is such a serious matter, and I understand it hasn't been done, but we do have the authority in the statute in Chapter 1 of our state statutes. That's something that we have the right to exercise, in our duties to serve the people. So we don't have any house rules against it, and I think it's very important that it's applied. I think it should be applied evenly, and I would like to see it in all committee hearings in the House. And I thank the representative for bringing that up. And I would like to allow these witnesses, or I'd like to ensure that all witnesses in this committee are under oath. Go ahead.
I'd like to second that motion because RSA 1414 states any senator or representative while acting as a member of the committee of the legislature may administer a note. It's already in the RSA.
Correct.
I don't think we need to go any further by checking with the clerk. It's in the RSA.
Did you call me? So the clerk has ruled that we can administer an oath. You are not required to take it, but we can ask that you do. Go ahead.
Thank you, Madam Chairwoman. The committee that Representative Long and I serve on has the same, and Representative Panic, we have the same, level. I think all committees have the same level of importance. I think one of the hardest things for getting people to testify and come testify is the great amount of pressure that we have, particularly even abuse victims. We're going to deal with people here that have abuse and there's gaslighting, what their truth is. We really should just be open to hearing. It's up to us to discern what we take from that particular testimony, but I actually think it will limit the freedom to talk and testimony. I think it's an unnecessary, and I do think that it's insulting to do that. So I do not think that we should go that route.
Representative Weber.
I think the last thing that I would say on the subject is that, first off, we all hope and expect that the truth will be stated here. People who are not truthful are not necessarily going to be deterred by an oath, except to the extent that they might be prosecuted afterwards. And I just think that with the gravity and the emotionalism that comes with these most deeply personal proceedings, as others have said, one's emotions are entangled, and I think it's very unwise, but I can also count votes. So thank you for letting me say that.
Representative Long.
Thank you, Madam Chair. Will representatives and senators be taking oaths also if they're testifying?
Anyone who is testifying,
Okay.
I should expect, I think that it should be applied evenly to anyone before the committee.
Thank you.
And we have already had one person testify without taking an oath.
Correct. Yeah. So it's beginning now. Every witness will have an oath sworn. All right, sir. Would you, Representative Panic, would you perform the oath on the witness?
Do you have the oath? Do you need a-
I can do it. All right, sir, if you would stand and raise your right hand. Do you swear that the testimony that you are about to provide is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Does it not have to be either under God or under the pains and penalties of perjury if they're swearing an oath?
From what I have read, there's no particular form as long as it's understood that it's an oath. And that the one that I just gave is almost word for word the one that's given in federal courts.
Okay.
All right. So, let's see. Sorry, I lost your card already. Did you take it? Okay, Mr. Peruse. Franklin, New Hampshire? Okay. Do you know how long you're going to need for your testimony today? Okay. All right. Thank you for being here. Go ahead.
Okay.
State your name for the record.
My name is Joshua Peruse. Madam Chairwoman, members of the committee, thank you for allowing me to share my testimony today. A little bit of background on myself. In 2014, I was divorced, 3 kids at the time, and in the process of that divorce proceeding, I was homeless, and so at the time, I agreed to a parenting plan that allowed her to have custody of the kids, where I get parenting time as agreed by both parties. And that worked well for a while until it was untenable. The other party would not work with me as well as I was hoping. And so in May of 2023, I filed a motion in court to try and get that amended. After getting back on my feet, I worked through getting an apartment, and now I'm a homeowner. And so I'm in a much better position now to be able to be a parent for my children. So I have to double check. May 3rd of 2023, I filed a motion in court towards that end. And on the 5th, the other party was served by the sheriff. And on the 8th, a complaint was filed with DCYF. against me that I had harmed one of our children. And on the 18th, 10 days later, I was informed that there was a DCYF and detective investigation occurring regarding an incident that was claimed. A safety plan was issued at that time regarding one of the children. And let's see here. I appreciate you letting me refer to my notes just to make sure that I am factual. There was some contact between myself and the DCYF CPSW working on this, and I did self-redact, so if you need the documents, I can provide them. And the first safety plan stated, during investigation, the report of concern of physical abuse, exposing the child to DV and putting hands on, and non-negotiable using any form of physical discipline with the child or any of the children. That was the first safety plan regarding one child, and without my knowledge or permission, that was the other children were added. And I was working with an attorney when we had filed the petition in court. So my attorney was working with me and giving me some advice on this as well. It was reasonable to agree to it at the time. And I was informed when I was first called by the DCYF CPSW, it was apparent that she did not like me. It came across very easily to understand that she believed I was guilty of what they were claiming. And that was from the outset, 10 days after the case was opened with DCYF and when I was first notified. And I was informed that at that time on that phone call that I would have a home visit soon as I had talked to the detective regarding the case in a criminal matter. The same claimed incident. I had to talk to the detective, and then she would talk to me, was the claim. And then it continued where I was trying to get the home visit, and it was delayed and delayed and delayed, to the point where I was told in, let's see here. As I mentioned to you on the phone, our visit appointments have been tentative on the investigation process. Due to the investigation is still pending with the detective, we'll need to reschedule tomorrow's visit until the detective is complete, which was different than what I had been told on the phone. So her claim was that the detective's office had to complete their investigation before they would even agree to a home visit with me. And then further safety plans were enacted, and it was all verbal on my part, where she would call me and I would verbally agree to the safety plan. And the second one began with all the children were included, where they where they would stay with their mother. But there was no notification that I could not have any contact with any of them. The mother restricted my contact to the point where I had no contact at all for a month and a half with my children. And after this went on for a while, on June 13th, I sent an email stating that I revoked my agreement to the safety plan that restricts my contact and parenting time with the children. I still had not yet had the home visit on June 13th. And at that time, I was, the response on the same day was that they would have their attorney contact mine. And at that time, we had informed them that there were witnesses to the time period where they claimed that an incident happened. And at that moment, still June, Nobody had talked to any of those witnesses. The home visit had not been completed. I had requested records requests through DCYF, trying to get records showing anything that I could so that I could understand what even the allegations were against me. The CPSW did not notate any of that to me. And then on June 22nd, on my behalf, my attorney sent a letter stating that I had not seen, spent any time with, or had any sort of contact with my children in over a month and a half. Despite my recent rejection of the safety plan, the children's mother has taken the position that the safety plan remains in effect and stands for the proposition that I must have absolutely no contact with the children. At that time, he had spoken with law enforcement, and he stated that the detective had told us from the police office investigating that they did not advise DCYF of any position against parent or child contact. They further stated that they communicated to DCYF that it does not need to wait for the police department to further its own investigation. DCYF had full permission to do the home visit, and yet they were still not doing it. Sorry. Then we received a response on July 3rd. My attorney sent the letter on June 22nd. We got a response on July 3rd. I still had not had any time with the kids. That they understood that I no longer agree to the safety plan. It's a voluntary safety plan. It's no longer in effect. They agreed to that at that time. They had asked the mother to be protective of the children. And that was on July 3rd, where I received that. And the timeline from there becomes interesting because on July 14th was my arrest regarding the incident, and I was released on PR bail. And then I received a notice of no complaint on September 12th. The DA was not going to further the in court. 2 days later, I received the notice of finding from DCYF. So the notice of no complaint was filed by the DA on September 12th. 2 days later, on September 14th, DCYF filed their letter of finding. They found against me, but I had not been offered. Sorry, I did not mention when the home visit happened. Actually, it did happen. Sorry. Okay, the DCYF home visit happened on August 25th. We presented our evidence, and we spoke with the DCYF CPSW for a good while, probably about 2 hours. Upon receiving the records from DCYF about this, that home visit, and absolutely none of the evidence that we presented was even included in the report. And the final letter of finding from DCYF like I said, it is self-redacted, so I will not speak anything that should not be redacted. Two children were interviewed during the process of their investigation. They both stated that I did perform this allegation, the alleged incident. No other investigation was notated on the letter of finding. On July 18th, I turned myself in for the charges brought against me by the police department, the charge of second-degree assault. But again, I received a letter of notice of no complaint. But it states that based on the foregoing, that child is an abused child, and I am the person responsible for that abuse according to their finding. DCYF has determined that I, Joshua Peruse, are the individual responsible for the abuse described above. As a result of this finding, my name has been permanently added to the DCYF Central Registry. I was not taken before a hearing. The only contact that I had with DCYF during this entire investigation was with the CPSW, minor contact with her supervisor, and my attorney talking with their attorney. At no time did I sit before a panel or any grouping of individuals where I was able to actually present evidence and to be included in the final report or for consideration. And yet they state that on the preponderance of evidence, I am guilty. That was their wording. Preponderance of evidence. Sorry, I forgot to read that, but that is in the finding. And that is based on the testimony of 2 minor children, not the 4 adults that were also there, which I had given them names, phone numbers, contact information for each of them, and they were all willing to testify on the behalf of the children. I'll open myself for questions if you have any.
Thank you. And thank you for being here. And I understand that this is painful and details are hard to get through sometimes. So we get that, and we're very patient, and you did a great job.
Thank you.
Are there any questions from the committee? Representative Long.
Thank you, Madam Chairwoman. Thank you for your story. This is exactly what we're looking at, and you articulated it well. Was there any police finding?
The police presented the case to the DA, and the DA rejected it. There was no finding by the police. I did not stand in court before a judge regarding the criminal matter.
And a follow-up, if I may?
Follow up.
Was there a Child Advocacy Center interview?
Yes, with 2 of the children.
with
But
two-
there were 3 other children present that day. There were no CAC interviews regarding them.
So my understanding is the complaint was on 1 child.
Correct.
DCYF included the other 2 children.
The 1 child and the testimony of 1 other child.
Okay, so they were involved too. And CAC interviewed one of the children?
The child in question and 1 other child.
Okay.
That was the only CAC interview that I
Were-
was made aware of.
Were you or your attorney present?
Negative. We were not informed of it until after the fact.
Okay, very good. Thank you.
Representative Kofalt.
Thank you, Madam Chairwoman, and thank you for your testimony and for taking my question. So you described the first conversation with the CPSW and made the statement, and I think I have this right, it came across that she believed I was guilty.
Correct.
So that's a subjective
Absolutely.
judgment about that call. Can you offer some sort of factual context to help us understand what was said, by whom, and just a little more background on that conversation so that we can understand it?
Reasonable request. I appreciate the opportunity. When she called me, the tone was forceful and honestly argumentative. She presented herself, introduced herself, and stated that when this incident happened, and and followed questions behind that. Assuming that the incident had happened and the tone of voice was, again, forceful, which to a point I understand. As a female, talking to a male who has been accused of certain things, there is a certain tone that must be necessary. But, sorry, forgive me. It was, trying to think. I didn't write notes about this particular phone call, so bear with me, please. There was an accusation at the beginning, during the phone call, that I had done it. It was that we're talking about the phone call. Yeah. Okay. Oh, wife's helping me out. The
Sorry, I would say that probably if you don't remember the specifics, don't reach for them too much, but we understand the idea that you felt it that way. Sorry, I should have
Representative
raised.
Weber. Oh, you have a follow-up, Jim? Sorry.
I do. Thank you. So I guess I just want to clarify. It sounds like you're saying that she referred to the accusations as fact, as factual,
Yes.
not as accusations.
Correct.
Am I accurate in describing what I heard from you?
Yes, you are.
Thank you.
Representative Weber.
Thank you, Madam Chair, and thank you for being here today and sharing your story, which I can't imagine could be easy in any way. You alluded to this, but I just want to clarify and be sure I have this correct. There was, the criminal prosecution was discontinued, is that correct?
Yes, ma'am. Yes.
And then there was no judicial proceeding with respect to the abuse and neglect complaint. Is that correct?
That is correct.
So you never went to court on that?
That is correct.
And then your name was placed in a registry?
That is correct.
And you didn't have any chance to challenge that before it happened?
Before it happened, no, I did not have that opportunity.
Okay. Was there an opportunity after it happened?
The opportunity, along with the letter of finding, they did tell me that I could appeal it.
Okay.
However, with the proceedings going on with family court and trying to gain some type of parenting plan with the other party to be able to spend time with the kids, I was advised by my counsel to not pursue an appeal. You're welcome.
Representative.
Thank you, Madam Chairwoman, and thank you. I'll echo the thank you for being here to testify. We know it's not easy, especially with circumstances and involving children. I just wanted to clarify, bring you two questions, if that's okay. What was your relationship up until the complaint, which was filed on May 8th? What kind of contact or relationship did you have with the children up until then?
Up until that point, every other weekend they would spend with me,
Okay.
as agreed by the other party. Sometimes it would happen. Most of the times it would.
Okay. And when, thank you for answering that. When was the incident that was alleged to have occurred? What was that date?
It was 3 days before. It was the Friday before that. So if I have my calendar here. So, okay, so it was the Friday before, so it was the 5th.
So the 5th. And you said that you filed paperwork on the 3rd, correct?
Correct. Paperwork was filed on the 2nd.
Okay.
The alleged incident on the 5th, and the DCYF complaint was filed on the 8th.
Okay. Thank you very much.
Any further questions from the committee? I have a question. What are the consequences of having your name on that registry? Do you know?
I'll be perfectly honest. I do not know. It was not explained to me by the DCYF CPSW.
Okay. And were you ever able to have that finding overturned afterward?
I had a limited window within that I was told that I had availability to appeal, and that window has long since expired. But I haven't, I believe, 1 year from the date of finding that I am able to get that expunged, which I will be seeking to do.
Okay, thank you. Oh, Representative Long.
Thank you, Madam Chair. The current status that you have 3 children, are you able to visit with any of those children?
Yes, actually, many things have gotten positive. With the family court, the other party and I actually came to an agreement where I have many weekends with them now. They stay with me from Friday evening through Monday morning. It used to be only pick them up on Friday night and I get them until Sunday night, but now I have even more time with them. We have a far more organized parenting plan where I actually share legal responsibility for them.
That's great, and that's all 3 children.
Yes.
Super. Thank you.
Not seeing any further questions. Thank you very much for taking the time out of your day to come testify. This is very helpful.
Thank you.
We will go to the next witness. I will call Katrina Hinrich, Exeter, New Hampshire. And if you are going to speak today, I see there are more people in the audience than I was going to say. I see you're passing out pink cards now. Make sure you fill out a pink card. Thank you. Okay. And if you wouldn't mind standing and raising your right hand to swear an oath to truthfulness in your testimony, do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
In the testimony that you're about to provide?
Yeah.
Thank you. You may proceed.
So there are some handouts coming to you. I just wanted you to be aware of those. Good morning, everybody. Madam Chair, thank you for allowing me the opportunity to speak today. I am Katrina Hinrich. Today I'm going to speak to you from a place of experience, a little bit of research, background, and organizational compliance and financial industry for me. And while the education and professional experiences have allowed me to better understand the function and issues of family court, due process, the associated agencies, there's nothing as insightful as being in the New Hampshire family court system for over a decade. This is my experience and my conclusions. DCYF was involved very quickly in my case and very quickly fell off. While they came to visit, they decided that there was no help they could possibly offer us in the abuse that was occurring. I asked for resources, none was given. You have to talk to the police, you have to do this. No matter what avenues I took, nothing was helping me. I felt as if DCYF was kind of putting up a wall, and they were so disinterested in my kids. With that said, in a post-divorce scenario, I found myself in family court for no stated reasons, but yet we were there. So over the decade that I experienced this, I can confidently say that my blind trust in the concept of court and expectation that truth and evidence would put an end to the post-divorce frivolity and abuses was actually, in the end, the very qualities I felt they were looking for to protract the case. And it fostered conflict. And it also revealed a lot of perjury. And in one of your handouts, you'll see it says perjury in family court of New Hampshire. This was written by a Manchester attorney named Shauna L. Brown. She subtitled it, The Truth, the Whole Truth, or, well, something like the truth. And if you'll refer to the first page of it in the second paragraph and the second sentence, it talks about, due to the nature of family court system, potential for perjury is great. And if that's the case, as she goes on to absolutely solidify, due process is being subverted at every angle, every institution. Further down, she says, Professional Conduct Rule 3.3 requires us all to correct the record. Instead, the attorneys quit and they never correct the record. And that happened in my case a lot. And later you'll hear me speak that we had over 15 attorneys in the case, over 5 judges over this decade. On the second page, you'll notice that she talks about perjury occurring, and the result, and I'm bringing this up because this is what I felt and what I experienced, is that the offending party being awarded for their conduct while providing no relief at all for me and my children, the innocent party, and yet we incurred all the legal expenses and the emotional distress and lack of effort, or, as far as I could tell, the court interest in revealing the truth. So again, due process. The reality that she writes is the same thing I experience. The party who is willing to lie under oath is oftentimes rewarded, while those who attempt to tell the truth are not. This is beyond the norm to me and a big due process issue, because I found out that my case was basically based on perjury. There was no due process. They were artificially creating the case. And please understand, this is a post-divorce case. Everything was said and done. We were safe. The other person was free to do what they wanted. But here we are, pulled back in for no reason that was evident. No evidence evident. It was just repeated process that went on for 10 years. She does offer some things on the back page about solutions. She says that attorneys need to start reporting issues and taking any and all necessary steps to ensure that perjury is taken seriously. It's a due process issue. This includes requesting orders from the family division to refer that perjury issue for prosecution to the county attorney's office. These are things I tried to get done myself and was constantly met with one thing. And that was, this is the way it's done. And if you do this, you might not see your children. And that was a constant threat.
I would like to just ask. I know you had some involvement with DCYF, or you tried to reach out to them for help. So I'm sorry to stop you in the
No,
middle
no,
of
no,
your
it's fine.
testimony. We want to kind of keep the testimony focused. Can you just explain how what's going on in the divorce court relates to DCYF?
Because if DCYF had actually done what needed to be done at that point in time, there was, and they were well aware, there was the opportunity for my children to be removed from the country and the state. They were well aware of the assault that already occurred, and yet it was just not enough for them to get involved to help us. So again, we wind up back in family court with this due process perjury issue. And as I've already heard somebody talk about, it seems like it's just accusation and, we either accept it or we don't. So that's why family court in my case is a major issue. Does that answer your question?
Representative Weber, for follow-up.
Thank you so much for allowing me this follow-up. I'm just trying to clarify where we are at this point.
Yeah.
So your concern specifically with DCYF was that they did not follow up and react in ways that you thought they ought to, and that they were not as serious as they perhaps should have been about the concerns that you had about their kids. Is that a fair statement, or am I misunderstanding?
No, that's
'Cause-
fair.
'cause
That is.
I just want to clarify that the thrust of this particular committee is DCYF and whether they are fulfilling their duties. And the family courts is a whole different thing. And I understand that it is part of your story, but for us, the focus has to be on the DCYF portion. So I just wanted to be sure that was clear. And thank you, Madam Chair, for allowing that.
So before you continue, I'll go just a step further to clarify. So the DCYF statutes are intertwined with the family court statutes. But I think that the way that certain cases are dealt with in family court by those statutes, depending on the nature of them, it might be a different experience. So there is overlap for sure with the family court. So it's not totally out of the wheelhouse of this committee. But the point is taken.
Yes.
Let's relate it to.
And that's where we're getting back to right at the moment, which
Thank you.
is, and to your point, thank you for the introduction on this. The reason that I mentioned the out-of-state issues is that is exactly what happened. We had parental orders in place, and everything I kept telling was happening was going to happen. I'd been threatened with it. I knew. I was giving them the facts. One of the attempts was literally taking my two youngest kids to France. Everything was in place. They were already enrolled in an American school. Luckily, another agency, and it was a school system, believe it or not, intervened. And that we were able to stop the removal of the kids at that point and get them back in the United States. The second event, why I tried to approach DCYF again, saying, look, it's already happened once. I know this is going to happen again. I just don't know where. It happened again with one child. So the next child was removed and sent out of state 1,000 miles away to complete strangers. And again, I could not get any help. Every time I went for help, it was, well, you're in family court, they'll solve it. If my daughter went to the police for help, you got to go to family court. So no matter what agency we went to, it was family court related. And yet I'm trying to get help. And it was just being pushed back into that system. So does that help clarify? Okay. Yeah. Yeah. And I will add that in the scenario when a child has been removed, it does actually qualify under the kidnapping law. And while that was brought up in court, they do not apply the law in courts. So it was thrown out and considered irrelevant. The child did not willingly go, but the child definitely came back. And the minute she was back, she was diagnosed with severe complex PTSD. She is now an adult, and she still is in taking care of her health and putting that first to undo what was done to her, which could have been prevented if we'd had the right resources in place. So the due process issues for me could be in any agency, but a lot of it happened in family court because that's where we referred to over and over and over. So what I did for you guys is in Appendix A in the first testimony sheet, I outlined the subjects of due process that not only have I heard from my case itself, but heard from other people. And in those due process issues, that's a lot of issue, and that's just 32 of them that somehow relates back to due process. And you'll see near the bottom, I really do specifically talk about, and I've heard this from other people, the removal of children from a parent without evidence or trial, and the removal of rights and freedoms and liberties without trial. Then you have no mechanism to get them back in the state.
Did anybody find it?
Yes, it's
Thank you.
behind that.
Thank
It
you.
starts here.
Thank you.
So there was no legal remedies no matter what we did. And we had to go through this with no way out. What I didn't understand was the makeup of the family court. I did not understand that that wasn't a judge, or that these orders were invalid, or that they were full of the libel they were full of, that I could do something with that. I had no ideas about that. And nobody in the organization was sharing, no matter how many questions I asked. So again, my kids wound up being the victims of something horrific that had already been settled with divorce, and had already been settled when I went into court the first time, family court, saying there's nothing to be here. But we went into family court on, I guess you would call it a modification. The other party decided they weren't going to pay, they weren't going to work, they weren't going to whatever. And over that period of time, it just snowballed into a decade of horrible, horrible things. So the DCYF piece for me is very valid and very real. But again, I was pushed off on other issues, ending in the due process problems. Is that helpful?
Any questions from the members of the committee? Representative Long?
Thank you, Madam Chairwoman. Thank you for your testimony. Was there a complaint filed with DCYF?
Yes,
Complaint.
in
There
the
was a
very beginning,
complaint.
I filed a complaint with DCYF. Yes.
Okay, and was a complaint on abuse and neglect or potential?
I always presented things as potential,
Okay,
but there was evidence. So there was a trial of his assault.
okay. And also, your decree, was your ex allowed to remove children from the state?
I love this question, so thank you for asking it. No, not without permission. But more importantly, in the decree, he really didn't want them, but I fought for him to at least have them twice a month. And I almost felt like what transpired later, though I'm not going to say it's fact, was because I wanted him to be able to parent his kids, or at least have time with them as he got older. I mean, maybe he was going through something, whatever. I really fought for that. And I got it put in the decree. So we both had the same rules set in place. If we were going to leave the state, we had to notify it. In our particular case, he was like, go anywhere you want, this side of the Mississippi, go away, go, it was fine. It was all in the decree. Children and I were free to do as we wanted. So how do we end up back here in family court with our rights being taken away and the kids being kidnapped? It's an issue because DCYF could have helped us out.
Okay, just one last
Oh.
one, if I may. Where is it currently?
Where, I'm sorry, what?
Are you still threatened? Currently, where does this stand? This
Mine ended in about after 12 years it ended. So in 2019, we were out of family court finally. However, we're stuck, and I think this is important for everybody to understand because I know the victims will understand it when I say it. You're stuck with orders of libel. You're stuck with them. and you have no way to get rid of them. And that, due process.
Thank you.
Mm-hmm.
Representative.
Thank you, Madam Chairman, and thank you for being here and sharing your testimony. So I just want to understand. So you said that you put it in the decree that he had to, have the kids 2 times a
Not
month
had
because
to.
you
He agreed to it eventually.
Okay, but that was important to you.
That was
Yeah.
important to me. Absolutely.
Was it before that or after that that you told DCYF that you thought that there could be some kind of abuse that they needed to look at?
It was before and after.
Okay, thanks.
I have a question. You mentioned that the orders were not enforceable. And I understand that the orders for, parenting plans that come from DCYF petitions also come from the same court. So can you speak to that?
Yeah, enforceability. I will start with the fact that enforceability for me began when I found out I couldn't use my divorce decree as evidence. Then I started saying, okay, but where do I go? What mechanisms do I have? Nope, you got to go through this. It's the way it's done. Fine. Now we're getting these rulings and, we're opening up the child situation. We're going to start separating them out. Eventually they were all separated out and I had no way to get them back together. So I kept asking the court, enforce the divorce decree, enforce what we just, agreed upon last week. And slowly, step by step by step, they wound up removing the kids completely. And here we are again, stuck, no way out.
Representative Weber.
So can I follow up on that? When you say they removed the kids, are we talking?
The court.
The court, so did the kids go to their father or did the kids go, okay,
Yeah, the 2 youngest one went to the father.
okay. So basically what it was a complete reversal of the initial custody order.
Yes, absolutely.
Okay, thank you very much for
Mhm.
clarifying that.
Thank you. Any further questions? Representative Long? No worries.
Now through this process, were you pro se or did you have?
Sometimes I
representation?
was, sometimes I wasn't. It depended.
So 50-50 or,
Probably about that, yeah.
okay.
Yeah, I really tried to have as much representation as I could, but I didn't hire firms. I just hired for the moment when I needed to.
Okay, thank you.
Any further questions? Seeing none. Thank you for your testimony.
You're welcome. Thank you for having me.
Next to call up to speak, we will have Representative JD Bernardi from Southampton. Representative.
Yes.
Welcome to the committee. Raise your right hand. Do you swear that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may proceed.
Thank you, Madam Chair and committee. I'm Representative JD Bernardi, Rockingham 36 with the Southampton, Hampton Falls, Kensington, Newton, and Plastow, southeast border of the state. I sit on the Science and Tech and Energy Committee, as my background is in biochemistry, pharmaceutical development, nuclear engineering, Navy submarines. But I ran for office, and in doing that activity, I knocked on doors. And I always asked people, what is it that you're concerned about with state government? I may hear a lot of stuff about the feds, but every once in a while, I'm going to get that answer that relates to activities with the state. And too often, it was the family court system, DCYF. We're dealing with liars court and people that aren't doing their job. And they are hurting people, they're hurting individuals, and if you can fix it, it would be great. So, no legislator can do that on their own, but I did sponsor last year HR 14, which turned into the special commission looking at family court. They basically a parallel to this organization. What I want to commend this committee to do, and you've done it to date, is truly listen to those people that are aggrieved. You have citizens that have been hurt, seriously hurt, and they carry that pain forward for extended periods of time. Do not listen or put your faith in presentations by agencies or judges that talk to you for an hour and a half, telling you how wonderful their systems are, because that's what they think, they're doing. Listen to the people that have the problems. It is only by doing that that you are going to identify the patterns of activity or the problem areas with the systems that you can then get your hands around and potentially create solutions to. You're not going to hear the problems coming from the agencies. You're going to hear the problems coming from the people. It's that simple. And that's all I have to say.
Any questions from the committee? Representative Long?
Thank you, Madam Chair. Is there a rough, I don't need to know 2,000 doors you knocked on, but out of the people you spoke
2,000
with-
is about right, yes.
Okay, and what percentage would you say complained about DCYF or family court? Well, DCYF specifically.
What percent?
A rough guess. I'm not gonna
Most
go into
people
it.
don't have complaints, but it was probably the most common complaint that I had. There's complaints about make sure our gun rights are maintained, and then the court system. Those two were I would say the top complaints.
Any DCYF specific?
A few, yes.
Few, okay, great, thank you.
Any further questions? I have a question. At our recent House session on the bill for, it was HB 1288 regarding due process for UNH students and employees and people being accused there. We had a former New Hampshire Supreme Court justice in our resident member of the former member of the judicial system, Representative, sorry, thank you, Bob Lynn, give a speech, and he actually mentioned some of the elements of due process, and you motioned for it to be in the journal, and I just wanted to thank you for that because it did give us a little bit of insight. What is your understanding of the essential elements of due process?
Thank you. So Representative Lynn, former Chief Justice, he articulated in that speech the minimum elements of due process for an activity that was non-judicial. So here's hearings or proceedings in front of the university tribunals or whatever about various problems that they're nominally investigating. And he articulated in that speech the very minimum elements that one should be concerned about from a due process standpoint. If you're in court, those elements should be even greater. But these were the minimum. So I commend you to review his speech. And when you think about what elements should DCYF be using when it is reviewing cases, it's an agency, it's not a court. Those same criteria ought to be your minimum criteria you look at.
Thank you. No further questions. Thank you again for your testimony. Also signed up to speak is Lauren Vaughn of Concord, New Hampshire. Thank you. Thank you. If you raise your right hand, do you swear the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth? Thank you. You may be seated and just state your name and you can.
Good morning. My name's Lauren Vaughn. I live here in Concord, and I'm going to get super emotional, so bear with me. I truly appreciate this. And now I know I'm not alone. This has been 360 days that I've been without my daughter. On March 9th, I had a bad day. On March 16th, my life just stopped. They barged in at 9 p.m. only after doing what I was told, every recommendation, and they still took her at 9 o'clock at night. I talked to her at 10:45 that night, and then not again for 5 days. I was an hour from home. The CPSW recommended I go to a sober home or some sort of facility. In their first report, they contradicted themselves. Very first paragraph. I knew nothing on the way this goes. As I stayed at the sober home for longer than I attended, than I thought I would, which I'm real proud of. It was strict and it was very eye-opening. They didn't give me any paperwork. They didn't give me any notices. They didn't give me anything. I didn't talk to my lawyer a day before the prelim. I got to the prelim. I don't remember it. It was a blur. The adjudication was a blur. Nobody defended me. My lawyer didn't defend me. I was never asked. I never even spoke up until just recently. I've studied this for the past 360 days now. There is no due process in my case. There's not one sign of due process, not even them trying until recently. When I stood up at the last 3 minutes of my hearing, I said, Your Honor, I'd like to speak if I could. And the record off the needle, they could not believe I wanted to say something. I've had it. The only one paying for this is me and my daughter. I'm the only one she's got. They dragged family that is toxic to my mental health into this, and no relationship with my daughter, who's 7. Well, she just turned 8 yesterday. In 5 years. So my family doesn't even know this child, really. And this family member is able to take my daughter on sleepovers on the weekends. My daughter was ordered to transition home on November 30th because I'm in substantial compliance with all my orders, and I've been doing exactly what is told. I have not given them any hard time. DCYF, my first CPSW, the one removed her. She was off the case immediately. My second one, I didn't hear from her for months. And now the new one that I have thinks I am threatening and that I am going to follow them to their new foster home. I don't have a car, and she's very aware of this. The reports that they give to the court are nothing but defamation of my character. I'm known to many as a big crybaby, as you can tell. I'm choking them back for this. I have not done anything that has been threatening. What I've done is tell the truth. What I've done is follow the court order. They took Christmas from us. It was ordered by the judge that she would stay home. The judge looked at my daughter and said, I want you to be home for Christmas Eve. Saturday, on the 23rd of December, I got a phone call from a number I don't know, from a woman I don't know, from the division, telling me that my visit was canceled. No sleepover. No explanation, no nothing. The foster mom that I had before the one now We had a working relationship. We had a business relationship, and it took a long time. And I appreciate her very much still to this day. We said, we'll just do it by the book. We'll just do it like this. They made up, no CPSW was there. There was like 5 cruisers, and we knew this was going to happen. And we followed everything. I brought all my paperwork. I showed them the court order. I did everything I was supposed to do. Not one thing in the report that DCYF made to the court was true. Not a lick of it. And none of them were there. The police report, I tried to obtain it. And of course, I'm not going to be able to get it within 90 days. So that's out of the question. I'm still waiting for it because I will bring it up. The fact that the judge looked at my daughter and said, you want to stay home for Christmas? And then I told the DCYF worker, you tell her. So I put her on speakerphone in the middle of Hannaford's. And I said, you tell her that you took Christmas from her. She didn't like that. I'm tired of letting my daughter down. They have took visits from us, and they have given not one reason. I'm exhausted, and I'm not done. We're coming up on a year. I firmly believe, and we're not, because, I'm not going to get any honesty from them, that she's with PREA doctors currently when she was supposed to transition home. There's no fosters left in Concord. I stayed with the foster system when they removed her instead of going to family so she could stay at her school because it would have been normalcy for her. And I didn't know how bad this was going to go. They said it was temporary. And a year later, she's been moved. I've had 3 lawyers, 3 CPSWs, 3 judges. The only thing, 2 foster homes, and the new one now, they think I'm a monster because they believe DCYF and all the reports that they make that I'm a monster. They don't let me talk to her. In 1 year, I have never missed a phone call. At 6 p.m., that phone would ring on, and she'd pick it up because the foster mom knew I was going to call at 6 o'clock. I never missed a visit, never missed a doctor's appointment, never missed a school function. I have not missed, not a beat. And now I'm a monster. And I already am very well aware the court has not been fair. There has been from the point of removal, I have court on the 14th. And I pray to God every day that this is going to go in my favor. I have a new lawyer. I haven't talked to him. It's all based off one thing. Drug testing. They drug test in a clinical level. There needs to be forensic testing in court. So if the DOC is doing it, and drug court and probation, then family court needs to do it also. DCYF came to my house on several occasions, took urine samples from me, and off they went. And those were the ones that were positive. I have them all. No med list, no this, no that. I'm not on drugs. Finally, for once in my life, I'm sober for 5 years from alcohol. I'm an alcoholic. I was at the sober home because no other facility would take me because I'm not on drugs and I'm not drunk. They don't see that. And I took their recommendations and I found the very hardest home I could go to. So structured. It was faith-based. It was a Christian home. And I still, to this day, I have that Bible right behind me. It comes to every court date because the only thing I got in this is God right now. I can't do any more than what I'm doing. I've done it all. I've finished parenting class. I've finished my program, which was amazing. It's like the first certificate I ever had from a program that I was proud of. And they never even mentioned it. Never even mentioned it. I had an amazing letter written by my LADAC. The LADAC at their office he doesn't even want to meet with me no more. He's like, I just don't want anything to do with this case. All of a sudden, he can't read drug test results. People are avoiding this case like the plague. And all I'm doing is trucking along, doing what I'm told. Now they can call my lawyer. I'm scared of them. I just filled out my ADA request. I can't do this anymore with them, the division. They violate court orders and it's okay. I would go to jail. They can lie to the court. I would go to jail. And they get away with, they were told by the judge, you are not to go above a judge's order. It was the first thing said within 5 minutes of the last hearing. The very next day, that's exactly what they did. The opposite. I'm tired of them and what they get away with. The due process it's been completely violated in many cases, but there hasn't been any. I had to look it up after a year of study. There's been 14, I think, statutes violated in my case, and I haven't even made it through the rest of it because I can't even stomach it. I start crying. I listen to people and I'm like, wow, something needs to happen. This isn't just here. This is all over the place, but I feel like here in New Hampshire, specifically Concord, where I'm in, only speaking for myself, it's like taboo. You can't talk about it. You can't do anything. This is the first time I'm saying anything about my case. Nobody wants to hear it. Nobody wants to. I'll blast it across the media at this point. My daughter was to transition home and she's been taken further away. She's been taken from me. Less visits, less parenting time, no phone calls. I was reported by the school. The school loves me. I talked to the principal. That's my buddy. What report was made? Oh, the one back in May for her hygiene. This is just, I pray. I pray that this meeting, something happens. Because I watch these all the time on YouTube. And I just hope that it actually goes somewhere and somebody hears something. Because we're screaming for help at this point. Thank you.
Thank you for your testimony, and I can hear the pain in your voice, and I understand this has been a very difficult ordeal for you. Would you be able to give us the list of those RSAs that you have found were violated? And if you have it
If you
now,
don't
we'll
mind
take
the
it
shot, if you
perfectly.
don't mind the highlighter.
Yeah, no,
Yeah.
that's fine. And yeah, those are particularly helpful to have those concrete examples of exactly where they went off. And I just have a question. Did anybody from DCYF ever let you know what your rights were?
No, ma'am. It's funny because I get laughed at about this all the time by many CPSWs. So there's a trifold brochure, a pamphlet, if you will, that they're supposed to give you upon initial meeting. Well, I had to print them. I found them. Actually, my boyfriend found them months later, and we printed them out. And I wish they would have given me that. It explains everything. It explains the process. It explains everything. I never stood a shot. I mean, 5 days, there's been an investigation made, and I was found a negligent mother. Various locations and various times is what they said. That's pretty vague. I mean, that's in one of these violations of one of these statutes also. I mean, as I go through and start reading the stuff, I find more. That's
Thank
why
you.
I had to stop here.
Thank you. Any questions from members of the committee? Representative Leon.
Thank you, Madam Chair. Thank you for coming and sharing this with us. And I'm so sorry that you've been going through this and your daughter is going through this. My question is about the drug testing. So they came and they got a urine sample from you where you live. Was there any process where you could go and figure out a way to do a similar test to show at a lab or something else where you were able to prove that it was in fact the urine that you provided, or did you not have that opportunity?
I didn't know. I didn't. So, because I didn't have a car, I was very open. The second CPSW, I had a great relationship with. Unbelievable. So when we did the home visit, she sent somebody else. I didn't know, and who was a very nice woman. And we walked around the house. We had a good time, and I did the drug test because while she was there, and then I realized that was kind of weird. No, like I've been in court before. I've been in trouble before, and I've done some drug testing. I've never seen anything like this. My sister works at a prison, and we've been I signed nothing. I actually currently have 3 contracts that are null and void with the lab, the ROIs, and just the foundation's counseling, which is the LADAC within the division. So I'm really not bound to them right now. So I did take 5 separate tests with Quest Diagnostics, and the CPSW never picked them up. And because of HIPAA law, it states I, in a court proceeding, cannot obtain my own results. So they went down the drain. Yeah. I And I tried to get in touch with her. She knew I was going. This was months ago. After I took the first test with the division, I realized that this was not, I was like, that just seems weird to me. Like, they just throw it in a bag and off it goes. Like, it's no ice, no nothing, whatever. So I said, let me try Quest. And she never picked them up. So I did it again, and I tried to do it smart. So I took a test with the division one day, and then I took a test with my doctor, and then I took a test. I tried to get into Quest, but I couldn't get in before they closed. They all do clinical testing. So if you're on any kind of medication that needs further testing, which it'll tell you right when you get your prescription, that the pain in the neck papers that they give you, read them. Last page, black box warnings. I knew none of this until now. They need to do further testing after the confirmatory. I'm working with SAMHSA actually to implement federal testing, forensic testing in child welfare cases, because this is absolutely the only reason I don't have my daughter. I mean, so they tested it at like an NG, which is little tiny bits. And I was like registering at 80.1, 80.6. Which is like a drop in an ocean. And now all of a sudden I'm back on my meds because I'm out of the sober home, and I didn't even know they would register at what they are. But they do, and it's in the thousands now. All of a sudden they're positive, and I'm like, but I'm okay. I gave them all the documentation they asked for, the pharmacist, my prescriber, everything. Black box warning. I gave them the prescription. They don't. Quest would have done the testing the way but it was like $250.
So could I have you follow up with me? Because I think that
Yeah.
might be something that's something that can be sort of pulled out of this whole process, but sounds like a really significant issue
Yes,
that
ma'am.
we need to deal with, but that might be served better outside of this full due
Yeah.
process thing. But this is a significant problem that has violated your due process, but
Absolutely.
it may be able to be discreet. So I'll give you my information.
Yes, ma'am.
Thank you.
On the 14th, they actually, DCYF was told that they need to bring in an expert if they're going to speak on drug testing results, because they are not LADACs. So I'm going to school to get my LADAC.
Any questions from the committee? Representative Wong?
Thank you, Madam Chair. I'm a person in long-time recovery. I let the tears out all the time, but if I don't, I use the fist. I'd rather let the tears out. So you're doing all right. You're
Thank
doing
you.
better than all right. Now you mentioned the two urine test positive.
All of them have been positive except for one in August, and I actually had COVID right before, so which is weird because I thought definitely that one's going to come up positive from meds or something.
Okay,
Cool.
and you're saying that it wasn't a deep enough dive into the pod. I know I tested positive with eating eating poppy seeds.
Yeah.
And
very
they have
easy.
to do it. I mean, I got let go from work, and they had to pay me
Mhm.
to find out that I was eating poppy seeds. You know, so I understand where a lot of times it's a deeper dive, and that's the positive ones you're saying. That's what that was.
Yes,
That
all
they
of them
needed a
have
deeper
been.
dive.
So
Okay.
with the due process, with this involved with like due process in court, when I presented, I gave them what they asked for, but they're not going to present it. Let me, I will. So I did, and I told the judge, I said, I've asked for further testing on samples, and they refuse, and then I won't hear from them at all. They'll avoid it until they want another test. I'm loading the ammo into the firing squad that's pointing at me every time I take a test with them. And then they're saying I refuse, but here I am, at the division for open access, like trying to comply. I picked up a contact log. The very first page said, I'm a rock star. I'm killing this program. And the last page says that I'm threatening. I'm frustrated because for once I'm actually doing the right thing in my life, because it's my daughter, like my child, my only child. And why wouldn't I do everything you ask me to do? Why would I become threatening? I become frustrated. I'm not being heard. I'm not getting fair trial. I'm not getting, like I said, I just spoke. It's been a year for the first time. And it's about drug testing. So I hope that on the 14th, this is mentioned, let's play fair. If this is going to be the issue, the drug testing, and own handbook, policy, and procedure they're not following. They'll test me back to back. They'll test me on a Tuesday and then they'll call me on Wednesday. And I'm like busy. And they give me an hour to get down there. You know, I mean, it's just frustration, not threatening. And yet, as you know, I mean, I've completed a program. I was in a sober home, but they didn't see it as that. And then they did in the next report. It's very hard to remain sober when they keep telling me that I'm on drugs.
Okay, good luck on the 14th.
Thank you very
Thank
much.
you.
Representative Panic.
Thank you, Madam Chairman. Thank you for taking my question. I'm sorry you're going through this horrible ordeal. I go to Quest for blood work every 3 months, and I'm on medication, and I don't do illegal drugs. And I also have been tested positive for poppy seeds. So, and I don't do drugs. So I empathize with your journey, and I think that part is very crucial on getting to the bottom of this. Thank you.
Hearing that just, look, you made me cry. Hearing that just, it confirms a lot, like, crazy.
Sometimes we need to be validated.
Yes, ma'am.
I have a couple of questions for you. You had stated that DCF lied to the court. Could you elaborate on that?
There's, I have everything. I didn't know how this goes. So I just brought, like their reviews, their reports, and I brought all the orders. You are more than welcome to them. The lies, the contradictions, and then the lies are kind of, I mean, there's so many.
Okay.
There's
So
so many.
are you able to maybe summarize where they violated RSAs, summarize where they
I wrote them at all the
lied?
top of everything.
Okay.
Just at the ex parte 169C, 6B, 169C 30.
Yeah, we'll take a list, and that would be super helpful just
You
for
are
us
more
to
than
boil
welcome
it
to look at
down.
this whole thing.
And I will take your question in 1 second. And then I just wanted to know also if you could give us a list of where they, in what instances they violated the court orders also. Thank you.
Yes.
That this is any information that we get, and you have been. I'm sorry. And you have been very circumspect and very careful in what you say to us, and I realize that that's an incredibly hard tightrope to walk, and we
Yes, ma'am.
appreciate you doing it. I was just asked to remind everybody that this is an open case, and Ms. Dyer, maybe you can help us. If we take any of the stuff that you have, it has to be redacted. Is that
Yes.
correct? So you would have to make sure that all the names were magic markered out or something like that. Would that be the best way for us to deal with this? Right. Yes. And I think for, again, as Representative Leon said earlier, this may be something where we need to find out exactly what we can have, because everything that we take in is public knowledge, and
Right.
we don't want to let toothpaste out of the tube about your private life, or in particularly your child's private life, in any way that could either reveal information that shouldn't be revealed or get you into some kind of trouble where what you're trying to do is walk the line and express your concerns, which is your right. So I'm hoping that, did you give us contact information when you filled in your
Very
pink card?
minimal because I wasn't sure.
Okay. You might want to provide that to us later on so
Yes,
that
ma'am.
we could get in touch with you, rather than taking information in that we shouldn't have taken and that we don't want to contribute to making
Right.
anybody's situation worse.
Oh, please, yeah, no, understandable. That's why I didn't make copies. I wasn't sure. Like I said, I didn't know how this goes, and with it being an open case, I wasn't sure. That's why I had like, the statutes, which is obviously, and the other things I have like things that that have been written about me, that never got submitted into court. That it's just how it's on due process. The other thing I'd like to bring up is that I have the summary, the case summary, and they had 8 return to sender pieces of mail that I never changed my address. I had another case that was open that kind of was the whole reason I got into this case, and I never got one piece of mail from them. I went to the courthouse where she said, "You have some returned mail," and she gave me a stack. It was all my rights to appeal. It was all my hearing notices and then all my orders. Everything up until November. And I knew I obtained all this stuff, like, as time has gone on. They have never given me anything. So I've never signed anything except for my acknowledgement of TPR if I don't comply, and the action and safety plan in the very beginning. That's the only things I've ever signed. And the one other thing that is now null and void.
Representative Kofalt.
Thank you, Madam Chair, and thank you for taking my question. So I just wanted to ask for clarification about the mail situation that you just described. So am I to understand that the court mailed documents to you, those were returned as undeliverable or rejected, refused return to sender? On what basis were they delivered? Are they would typically be marked on the outside
I know,
of the
and my
envelope?
boyfriend's a letter carrier. So I have a good relationship with my mailman, not him, but we know how I worked for UPS. So, I mean, he works for USPS. So there's no reason, because I never changed my address. What I did was have a hold at the post office for my mail. The only thing I did change was DHS because I was at the sober home, and it allowed my food stamps and stuff, because I paid for that sober home, to go there. So there was no RTS on anything. It was just, I don't have any of the envelopes that would have said any of that. What I have is the stuff that was inside of it.
Follow up.
Okay, a follow-up. So when those items were given to you by the court with the statement that these were returned to us as undeliverable or refused or something, they were not contained in an outer envelope?
No, sir. They had a binder that was clipped at the top, and it was just like a 2-ring binder she even had to go get another clerk because she said she's never seen anything like this. So, and she had to sign everything out. So, yeah.
Thank you.
Yes, sir. Thank you.
Representative Weber.
Thank you. And my question would be your relationship with your attorney. The things like the report from the LADAC or the reports from the sober home, did you provide those to your attorney, and what happened at that point?
This is attorney number 3 that I have now, and he hasn't even gone to court with me yet. We've met once. We've talked 3 times on the phone. The first attorney I had, he gave nothing. I gave him stuff. He gave nothing to the court. I'll just say I don't have anything nice to say, so I just have nothing to say about that. The second attorney, she was amazing. She did 2 hearings. Court was in my favor. Things got turned around. Substantial compliance. Bawling my eyes out of the courtroom and hugging my kid. And now that she left, she withdrew after the last hearing, and they got a new attorney, which was the attorney I was trying to go for the minute I left the sober home. They have her now. So I was like, wow, plot twist. And she's vicious. And I don't know how he's going to do it, but he seems very confident, and he has an expert witness, and I just pray the 14th is going to go well. I've given him some stuff, but I guess he has a box full of stuff. I've asked for the discovery from the division, part of the way you're supposed to. They won't give it to me. The email was actually intercepted because I got a response back, and then it was one of the head field reps know. They knew that I didn't really have a lawyer.
So could I clarify further?
Absolutely.
Thank you so much. So, I got a little confused there. So the attorney that you have now, is that the attorney that has the whole box full of information? And have you made sure that your current attorney has all of those reports that you
Yes.
had
Yes.
and is aware of those and so can get those to the court?
Yes. So the first time we met, we had a very long meeting, and we got a lot done.
Okay.
And I gave him everything I had, and he was pretty confident that a couple of things that I gave him, he was like, well. It was funny because when I walked into his office, he said, "Oh, the drug test results are back," and I was like, "They've been back. They've been back twice now. So this will be the third time. Different copy, same drug test, 3 different results."
So is what
Oh.
you can see that I'm trying to get at
Yeah,
is, are you now, whatever happened in the
I hope
past,
so.
are you now receiving what you feel is effective assistance of counsel as opposed to a counsel who isn't paying attention?
I hope so.
Okay.
I hope so. I don't know until
Me
we get
too.
in front of the judge at this point, because I had a lot of trust and faith in the system, because I've been through the system before, and this I don't have any faith in. And you never know. This case changes on a daily basis, and it's Monday.
Representative Kofal.
So
Thank you. Thank
Thank
you.
you.
I just wanted to delve into that aspect because it's an
Yeah.
aspect we haven't talked about yet. And it's
Right.
very helpful to hear your perspective. And thank
my
you.
first attorney, I did ask him to withdraw several times. We did not have a good relationship at all, and he refused. He actually told me he was doing me a favor by not withdrawing.
Thank you.
Representative Kofal for a question.
Thank you, Madam Chairwoman. So I just want to see if I understand correctly. So current opposing counsel is somebody you described as a very aggressive or effective attorney. Is someone that so that person is representing the division currently?
Yes, sir.
Okay, and that is somebody that you wanted to hire as your attorney at one point. Did you ever consult with that person?
Her secretary. No, I never made it to her. But yeah, that was the first thing I tried to do. I'm like, conflict of interest. Wait.
Okay,
They were like, nope, sorry.
thank you.
Representative Gregg.
Thank you, Madam Chairwoman, and thank you for being here today and sharing your story. And congratulations on your sobriety.
Thank you.
It's more not so much a question, really. It might be helpful for you to tell us, like specifically where DCYF, where you felt like they didn't do what they were supposed to. However, before you do any of that, back to this as an open case, and you do have an attorney now, I'm not sure that I would give us much in writing before you consult with your attorney, because we certainly don't want to jeopardize your case or your daughter on something small. So I would
Right.
just highly suggest that you speak with your attorney before giving us anything in writing. But we do hear you, and it's very, very important. So thank you for being here.
And that means everything to me, really. I'm going to his office right after I leave here.
Any further
Surprise.
questions from the committee? Thank you very much for your
Thank
testimony.
you very much,
and,
everybody.
And we're looking for process issues. So whatever you send us, we really don't need names. I want to know where the issues are in the process.
Yes, ma'am.
Thank you.
Got it. Thank you.
Next up to speak, we have Andrew Noes from Bethlehem. Andrew Noes. Noyes. Thank you, sir. Raise your right hand. Do you swear the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may proceed.
Thank you, Representative Cushman. I find it interesting that the discussion here started about oaths, concerning oaths. We're hearing a lot of issues here about lack of truthfulness, lack of oversight, lack of accountability, and everything I'm about to present here concerning due process all really kind of goes back to that. And I think that it's really important that we remember that DCYF and the legislators that are involved with the oversight of DCYF all swear oath to the state constitution. So with that, due process. The Bill of Rights in Article 14 and Article 15 reserve back to the people the right to remedy, a swift remedy without denial. It's supposed to be prompt and without delay. Again, that's something that we're not really hearing in testimony here. And Representative Cushman, thank you for responding to the will of the people and their lawful instructions to look into this matter. And of course, you have the notices and affidavits from the people who are willing to hold an account to what they have seen, what they see, and the lack of due process here. In Article 15, the Constitution says that no subject shall be arrested, imprisoned, despoiled, or deprived of his property, immunities, or privileges, put out of the protection of the law, exiled, or deprived of his life, liberty, or estate, but by the judgment of his peers, or the law of the land. It's a maxim of law that no free man shall be deprived of life, liberty, or property, but by the lawful judgment of his peers, or by the law of the land, that is, the common law. Black's Law fourth definition of the law of the land is due process of law. And so it's really interesting here as you start to look into the founding generation's understanding of what due process is and how that is going to correlate to this term law of the land. And the constitutional view, which everybody understands here, is your main prerogative, and everything else is going to follow out of and flow out of your constitutional obligations. That these two terms really go hand in hand. So due process of law, by law of the land, is most clearly intended, that, again, this is from Black's Law, intended the general law which hears before it condemns, which proceeds upon inquiry, and renders judgment only after trial, Black's Law fifth definition of common law action is an action governed by common law rather than statutory, equitable, or civil law. So I want to pause there for a second. There's a lot of discussion around the statutes which may have been violated concerning a parent's right to due process. The parent's rights, as are secured in the Constitution, are common law rights, rights which have been understood in antiquity and were very well understood amongst the founding generation to exist regardless of statutory law, and in fact are secured against any infringement by statute. That's very, very important here as we're looking into the process, into due process, and something that it's imperative that you really stress that and look into whether any statute which may be enacted or has been enacted already can deprive a parent of their rights. And interestingly, in part 2, discussing form of writs, Article 87, where it says all writs issuing out of the clerk's office and any of the courts of law, Black's Law defines court of law as, in a narrower sense, a court proceeding according to the course of common law, governed by its rules and principles, as contrasted with a court of equity. So just really wanting to nail down here due process as it pertains to parents, their rights to their children, to be heard before they're deprived of those rights, it is a common law right that the Constitution secures. Now, why am I going back to these definitions, and why am I stressing that the Constitution understands the due process, the concept of due process in a certain way? Why did the founders understand this in a certain way? Well, often we'll hear that the the standards have changed and that there's different considerations, and maybe DCYF needs to be involved and certain statutes need to be enacted because the world has changed, because we have a different understanding of the rights of the parents and how that pertains to the children, and not using a historical analysis method. And to that, I would say that you really need to pay attention to what's going on in the Supreme Court of the United States, as we're seeing a return to the historical analysis method. So in a recent case out of California, Justice Benitez in Fouts versus Bonta says, quote, "The Supreme Court focuses on the original understanding," and this was in a case pertaining to the Second Amendment, specifically actually billy clubs in this case, but the original understanding of the Second Amendment, and thus requires courts to give the greatest weight to evidence from the time period of its adoption. That is because not all history carries the same value. He goes on to say, of the 39 representatives who signed the Constitution in 1787, none were alive 50 years later. James Madison, known as the father of the Constitution, lived the longest, passing away in 1836. This is the most persuasive evidence that the original understanding of the Second Amendment protects a person's right to keep and carry a billy. So, in this case, obviously they're talking about a billy club, but I would really stress to you the importance to see that even the Supreme Court is recognizing that for too long we have used that government agents and officials have used precedent as an excuse to violate the people's rights in error, when the true standard, and again, returning to due process, the true standard must be the historical understanding. And when the founders wrote in our Constitution, the New Hampshire Constitution, in the Bill of Rights, that the people shall not be deprived of their property, of their life, liberty, or estate, and I think we can all agree that children are liberty interests, but by the judgment of their peers, that is very specifically meant to be understood as these people need to go before a jury of their peers, have the right to trial by jury, and for any accuser and anybody who's going to make an accusation to have to swear an oath attesting to the truthfulness of what they say before they can be deprived of their children and of their right to be a parent. You'll see again in Black's Law that really you can summarize due process in this statement, that if any question of fact or liability be conclusively presumed against him, this is not due process of law. Representative Cushman, you're aware of Worcester v. Plymouth, and that it's ripe with references to the right of the people to a trial by jury. And one of the things that are stressed there in that decision is that there is a very important distinction between Part 1 and Part 2 of our state constitution. Part 2, Article 5 gives authority to the general court to make laws, and gives it power to enact certain statutes and such, so long as, quote, the same be not repugnant or contrary to this Constitution. It says that twice, and that's pretty important. I think that they put that there twice because the founders really wanted us to understand that any discussion of rulemaking or statutory authority has to come underneath and follow after the rights of the people, as is reserved to them in Part 1. As far as I'm aware, there is no authority existing anywhere to abridge the rights of the people in Part 1. If you can find that granted to the general court anywhere, and especially the ability for them to grant something which wasn't granted for a body like DCYF to abridge those rights, I'd love to see it. I don't think you're going to find it, though. These are constitutional rights we're talking about, And again, Black's Law will inform us as to what should be understood as a constitutional right, and that is one that is so guaranteed as to prevent legislative interference therewith. I don't think you need to go much further than this. If you can't prove that there is any authority existing within the legislature or any bodies that it creates to take the rights of the people without a trial by jury of their peers who are sworn to the truthfulness of the statements that they're going to make, then you cannot take those rights, and only then can due process occur. Thank you.
Thank you for your testimony. Any questions from members of the committee? Seeing no questions. Thank you. Also signed up to speak. We have, actually, do we need a break? We're going to take a 5-minute break.
I think, Madam Chair, it would be very helpful if we have some kind of time frame, because I know that I'm coming up on deadlines not in the not too distant future.
Sure. We still have a number of people who are wishing to testify. I still have 3 cards. We don't need a quorum for the committee.
No, I understand that.
So if you have to leave, that's completely understandable in your purview. I'll be here as long as I need to continue hearing the people who showed up today and took the time to testify. But I do understand that need. So if you need to excuse yourself, we completely understand. Yes. And I would just like to take a break, and I would like to caucus with the Republicans, please. Thank you.
Where?
Let's go in our office in the D2 cell.
Yeah, I'll find another place.
No problem.
We'll just give a few minutes for the other members to come back. Okay. If it turns out that Mondays aren't a good day, yeah, we can just talk amongst ourselves about this. You know, we can go for Fridays.
Fridays
So we
are
can
much
pitch
more
it.
difficult for me.
Okay.
I have things that are once a month and nothing's falling on the 25th.
Okay.
The other ones are I have a commission on aging, um, one Monday, and I have the Health and Human Services Oversight one Friday, and then I have both Monday and Friday meetings that are regular meetings, but can be dealt with.
Okay. And really divvying out where are the issues that they're talking, because we've had a couple that are repeat issues that have been raised. I think we can boil it down to actionable items that. Mhm. Sure. Testimony you're about to provide is the truth, the whole truth, and nothing but the truth.
I do swear, so help me God.
Thank you.
So, good afternoon, Madam Chair and members of the committee. There are some handouts, 5 in total, 4 one-pagers, and then a stapled one. In
Sorry, proceed.
Okay. In my case, there have been 2 different agencies involved, New Hampshire DCYF and also Los Angeles County, California DCFS, which is the analogous agency in California. So I may refer to both DCYF and DCFS. I think, first of all, thank you so much for taking the time to really hear everyone here and really let people tell their stories. And thank you so much for emphasizing the need for truthfulness in these proceedings. I think that's extremely valuable. What I'd like to bring to your attention are what I consider to be due process violations in my case relating to the review of reports from both New Hampshire DCYF and LA DCFS. To that end, the background of this is a family law case in with myself and the other party involving 1 adult child and 3 minor children. With both agencies, there were cross allegations of abuse. The allegations of abuse against me by DCYF were determined to be unfounded. The allegations of abuse by the other party were found to be indeterminate, meaning there was probable cause to suspect something was going on, but not enough to proceed further. So essentially putting in good faith, but we don't have enough. You don't have those records before you. They're in the sealed appellate file. I wouldn't personally have a problem with you having them, but I think the court system would. So let's not do that. The issue comes, and you've heard it earlier from so many people, is that these agencies are all intertwined. So it goes to DCYF or DCFS, and then it goes to the court system. And then the court system has to do something with that. And in my case, that's where things really fell short. So in my November 6th, 2020 family court hearing, all of these records are coming in as evidence. We've got cross allegations with agencies. We've got cross petitions to modify a parenting plan. So I would respectfully suggest this really matters and that the judge, maybe ought to look at those. Instead, during that hearing, the judge said, and I'm simply quoting him, "Who gives a fuck?" At the time, we didn't know he did that because it was a telephonic hearing. This is multi-state diversity of citizenship. So I'm in New Hampshire, judge is in a courtroom. The other parties either in California or Michigan. We actually still aren't sure which. And compounding due process from there, we then proceed to a falsification of the court record. And if you look here, there's an email from eScribers dated November 12th, 2020, concerning the court record that says, of course, we are not going to just transcribe that. So we are now intentionally omitting the misconduct from the official record. That seems like a pretty serious due process violation. If you go to the next handout here, you have an email dated November 13th, 2020 from Chief Administrative Judge David King, sort of writing all about this and telling the judicial officer there's an issue. So at that time, he's fully aware there's transcription issues, there's a misconduct issue. You know, this is all within a week of the hearing. I didn't find out till almost a year later. And after that, all going on behind my back without my knowledge, there's a misconduct investigation that's dated February 16th, 2021, where the Judicial Conduct Committee voted to dismiss this report for the lack of any showing of judicial misconduct, with no reasonable likelihood of a finding of judicial misconduct. Again, a copy to Judge King. So, you know, November to February, Judge King knows all about the falsification of the record. He knows all about the misconduct. I have no clue. I didn't even know this happened. You know, by the time this letter, the only way I found out was a proactive discovery request, essentially a fishing expedition to the JCC for reports of misconduct. Seems like someone maybe should have notified me. And again, this is all a hearing where we're supposed to be going over these DCYF and DCFS records. The other handout, I would draw, that's the last kind of one-pager. I mean, these are double-sided. An email from the judge in the case who signed the orders based on this hearing, that she knows nothing about my case. She says she suspects I was a co-signer, no recollection of you personally, no facts. She claims she didn't make orders substantively. Well, what does that mean? So we kind of went through a whole hearing on DCYF records and from 2 different states, with a judge who was out to, a Maryland master who was out to lunch, a judge who knows nothing about the case. And I kind of suspect nobody ever read these. What's probably most concerning to me, though, is if you look at the last sort of number 5, that's the only one that's stapled. The pages are in the page numbers are in the upper right-hand corner. It's page 26. We don't have the whole thing. A large portion of this has been redacted. I've been unable to get a complete copy. So that's a discovery issue. But on page 16, and it is again highlighted in yellow, sort of the most relevant part. Page 26, lines 12 through 16, Judge King is questioned under oath if he told the Judicial Conduct Committee. And he asks, did I tell the Judicial Conduct Committee what? And he's asked again about what you had found regarding the transcript in the Albrecht case. So this comes back to the record. And he says, yes. So he said under oath that he told the Judicial Conduct Committee about the transcript. Well, if he told the Judicial Conduct Committee about the transcript, then why did they dismiss the complaint on February 16th, 2021? So it is my belief that the Chief Administrative Judge, again, my belief that the Chief Administrative Judge lied under oath in his deposition concerning falsification of the court record in my case. And this is a very serious matter because what was before the court, are motions to modify, who's doing what with the kids and these investigations from both agencies. And as a result of that, my case has been delayed for years. I have not seen my younger daughters in several years. Even though my oldest adult son is home and has lived with me for years because he wasn't involved. And, they sort of moved all over the country, and we, I think nobody can track that down. And just to kind of end on something somebody said earlier, there was a claim nobody wanted to look at their case. Well, I think the state wants to get rid of my case because as you move forward, we call a 3-hour sua sponte hearing, not at the request of either party, for the judge to decide that New Hampshire shouldn't have jurisdiction at all over parenting. When both parties, nobody asked for that. Both parties were happy to have New Hampshire retain jurisdiction. But at the same time, New Hampshire gets to retain jurisdiction over civil domestic violence allegations. And I guess those are more profitable than taking care of kids for the state. Thank you.
Thank you. Any questions? Representative Kofalt?
Thank you, Madam Chair. Thank you for taking my question. So one of the handouts that you provided was an email from Julie Introcaso at Gmail. On the back of that, it is highlighted. There's a statement, "I suspect I was a co-signer." I believe you referenced this briefly in your testimony. Can you explain a little bit more and sort of go into what you mean by that statement, or what you interpret that statement to mean?
Absolutely. So in New Hampshire, our Constitution provides for judges who take oaths and have the ability to issue orders. At the time she was responsible for my case, Julie Introcaso was the judge signing orders. Also involved in my case, hearing it, was marital master Bruce Dalpra, and that's a marital master. And the difference is they're not a judge per the Constitution. And I would refer the committee to Witt v. Justices of the Superior Court from the First Circuit Court of Appeals. It's a 3-page decision. I can email it to you, but it essentially says that masters have no inherent power and derive all their authority from the judge. So when she says she suspects she was a co-signer, I think she's trying to get out of having any responsibility for my case when she's the one signing orders in my case. That's how I interpret it.
Paula?
So am I interpreting this correctly then? So she says she has no recollection of the case. People, I'm sure people are busy. They cover a lot of cases, but I guess that what concerns me is that following statement, a decision that I did not make substantively.
That's very concerning to me too. I don't know what that means.
Okay. Thank
I
you.
would also, in her deposition dated February 8th, Julie Introcaso's deposition, she also discusses my case under oath, where she says she has no recollection, but knows that it's a notorious case. So if she's going to say it's a notorious case, how does she have no recollection?
I have a question.
Yes.
So when you ended up going, who originally petitioned? Was there a DCYF petition against one of you? you or your ex?
No, so the brief procedural background. My case started with false allegations of domestic violence against me, civil, by the other party. Those are often weaponized and used as a silver bullet in many cases to gain an immediate upper hand. Again, often used. Those were dismissed. As soon as those were dismissed, the other party's next attempt to essentially use agencies in the system as a weapon was then to file false reports with New Hampshire DCYF.
Thank you.
Yeah.
And when you were contacted by DCYF, did they give you information on what your rights were regarding due process?
They did not, or they might have. Let me just say I don't recall exactly what the handout said. I do recall telling them that I would be happy to speak with them when I wanted my attorney present.
Representative Weber?
Thank you. That's very helpful. And to go a little further with the DCYF portion of the proceedings. So you said you were willing to speak with them with your attorney present, and was a DCYF case ever brought, or were they simply involved because of the complaint? Or could you explain to us a little bit about what happened with DCYF? Because that's specifically what we're looking into.
Okay, and if I could share with just both the agencies, because they're both informative.
I understand that, but we're looking into
right,
New Hampshire DCYF, so
right.
if you could,
Right. But
if the other's necessary for our understanding, that's great, but
contrast.
if you could let us know about the proceedings with DCYF, that would be very helpful.
So, New Hampshire DCYF, she made one call that was completely dismissed. They didn't take it seriously. I mean, the DCYF. Then her allegations were then reported through her therapist as a mandated reporter. So that was enough to actually get something open. I believe neighbors also reported allegations against her in that complaint. And so you basically have an investigation opened against both parties because people are calling them. And while that's not enough for DCYF to take action, that's certainly enough to produce a report of who said what to where that should be admissible in a family court proceeding. You know, that a judge would want to look at to kind of help figure out what's going on in the case. And I could say the same essentially for LAD's, the Los Angeles agency. Again, that's initiated by the parties, but then the report should come into evidence.
And just to be completely clear, so there never was although there was a DCYF investigation because of all of those reports, am I correct in thinking that no DCYF proceeding was ever filed in court?
Yes. You are correct.
I
No
was correct.
proceeding
It
is
was
ever
not.
filed.
Okay.
Yeah.
I just wanted to be
Yeah.
sure I understood what DCYF's involvement was.
Yeah.
Thank you so much.
If no one else has questions, I have a couple.
Sure.
So when you were, when DCYF made contact with you and did their part of the investigation concerning you, they gave you a brochure, you said, and did they do a home visit? Did they interview your kids? How did that all go?
So my kids are not with me in my home. I told them I didn't want to speak without my attorney present. My attorney advised me to set up an appointment with them in my home with him present. And so my attorney and the social worker and myself had a three-way conversation at my dining room table per the advice of my counsel.
Thank you. And did you feel that the report that DCYF issued reflected accurately what occurred at that during that conversation?
Yes, but I did have, I would consider unnecessarily delays in discovery getting my hands on it.
What kind of delays? How are you delayed?
Just,
Specifically.
I mean, if you ask the agency with the report because your attorney wants it as evidence in a family law case, and this goes for, California as well, then both agencies should be provided a copy in a timely manner and not months later.
Thank you. And did the court just refuse to consider the reports as evidence?
I would have to go back. They were admitted, I believe. I would have to go back and review the transcript. They're certainly in the appendix in the appellate docket, sealed. But I would have to, I can get the transcript to you if you need it.
If you're allowed to.
I'm allowed to, it's public.
Okay. All right. Any further questions from the committee? Not seeing any. Thank you very much for your time.
You're welcome.
Also signed up to speak, I have, a request for a sidebar with a member. I will be right back. Yeah. It costs half as much in a parking building. It's 50 cents an hour there and $1 an hour on the street. And you can use a credit card. I never have quarters. You know what? My first one, in 16 years old. I apologize. All right, our next person signed up to speak is Dan Batton. Do you swear that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
So help me God.
Thank you.
So my intention with today's testimony and the written testimony that will follow is to use provable fundamental truth to help paint a picture for you, to help shine some light into the darkness of unlawful practices that have been hidden from the people for decades, with the understanding that due process, like all law in the state, must be viewed using fundamental principles that are not changed by time or political ambition. Before I dive in, I suspect I'm going to get some pushback from people who teach legal theory contrary to what I'm going to say. They might tell you that you have to look at due process through the lens of procedure, through precedent and statute. Some of them might even have the nerve to say that the people gave up some of their due process rights when they formed the state. That so-called case law is in fact the law, and they may call my statements antiquated or irrelevant. But just as you asked us today, which I commend you for, by the way, you should demand that those people support their claims in writing, make it clear not as theory, but with incontrovertible fact. Ask them if they are willing to support their claims under oath under penalty of perjury. Now, because there are many misconceptions about what the Constitution is, I'm going to offer a point of clarity from the New Hampshire Supreme Court, who said in its Worcester v. Plymouth decision, the division of the Constitution into two parts was not made without a purpose, and the name of each part is not without significance. The first is a Bill of Rights, and the second is a form of government. The second, in general, is a grant of powers made by the people to magistrates and officers of government who are declared in Part 1 to be the grantor's agents. And the first part contains a list of rights not surrendered by the people when they formed themselves into a state. By the reservation of these, they limit the powers granted in the second part. They exempted themselves to the stipulated extent from the authority of the government they created, end quote. Now, some people don't think of the Constitution as the law, but that's exactly what it is. It even says so within its own pages. Part 2, Article 101 says that the Constitution is the law of the land and is to be written into every law book for perpetuity. So both in theory and in practice, the fundamental law of our state, the law that created your office, which you all promised to support in advance of taking your seat, is clear that the legislature cannot lawfully interfere with the rights of the people for any reason whatsoever. Now, having laid that foundation, we can move on to due process with just 2 points of clarity. The founders, I suggest, knew that there would be times when evil would rear its ugly head. They were not strangers to despotic, tyrannical government. They were also well studied in history and law, and they understood human nature. So they made provision in the Constitution in an effort to protect the body politic and its citizens, but only under very specific conditions to allow for the taking of rights. My following point must not be overlooked regarding due process and courts. There are two classifications of courts: courts of record and courts not of record. A court of record is the only lawful recourse sanctioned by the Constitution for the state to take life, liberty, or property from one of the people. Now, the definitions of terms in the law dictionaries and the way that they've been taught at law schools have been changed. But the changing of the definitions does not change the meaning of the words at the time they were written. Now, SCOTUS has recently affirmed that statement, and the fallout of which is rippling throughout the court system around all over the nation, even as we speak. A court of record, at the time the constitutions were written, has 5 attributes that distinguish it from a court not of record. A court of record exercises functions independent of the magistrate, meaning the judge who works it is paid independently of the agency, people, and counsel before it. It has records and proceedings that are open to the public. So no sealed records, no closed courtrooms. It proceeds by the common law, not by statute. And unlike courts of record, unlike courts not of record, courts of record do have the power to fine or imprison. Said another way, they have the power to deprive of life, liberty, and property. And fifth, they generally possess a seal. Now, Legislative tribunals, on the other hand, of which a DCYF court is one, they do not operate independent of the magistrate. The magistrate is directed by rules of and is paid by the agency, working in front of counsel also paid by the agency. They do not proceed by the course of common law, they proceed by statute. Their proceedings are private, their records are often sealed, they're not open to the public. And legislative tribunals, by definition, are not courts of record and therefore hold no power to fine or imprison, which means they have no authority to deprive the people of their life, liberty, or property. Now, I don't want you to take my word for this. You can look for these fundamental principles yourself, and if the truth is what you seek, you will find plenty of support for what I'm saying. One of the features of a court of record that I want to clarify a little bit further is that it must proceed by the common law. And the reason I have to bring this to your attention here is because teaching about the common law is mostly factually incorrect. People teaching you might tell you that so-called case law has changed or even built upon the common law, or that case precedent is itself common law, but those claims are simply not true and are another example of something that has been hidden from the people. The common law is precisely that which is distinguished from law that is created by legislatures. It is of fixed and immutable authority. And since the judiciary does not make law, so-called case law is a myth at best. The common law is not some antiquated legal theory, nor is it difficult to understand. It is common in that it is common to all, and that it is easy to understand. And I will provide you with written testimony at a later date, and I'm willing to make more statements under oath to support my claims. But if you research this for yourself and find it to be true, then I need to ask you, does the legislature have any authority whatsoever to create an agency or a tribunal to take a child from a parent if that tribunal is not open to the public and has a magistrate who's not independent of the proceeding? I'm sure you know my answer to the question is that they do not. And no matter of expediency or convenience can make it so. Again, I don't want you to take my word for it. Look for yourself and ask, how do you know the answer to a question? The truth of the matter is available to you if you want to find it, and as agents of the people, it is your duty to do so.
Madam
Thank you
Chair,
for
I'm
your
just going to apologize to for my rudeness, but I had no idea that we were going to proceed this long, so I'm going to have to leave. And assure people that I will look very carefully at the tapes going forward.
Thank you, Representative Weber. Thank you for your testimony. I have a question. You are saying the definition is in Black's Law 4th, and I actually sent out that definition from that to the members of this committee today of due process, and it does allude to, if I can find it, to common law. It's this one with the notes, which I didn't mean to include my comments, but I was breaking down the definition and trying to really parse it out to figure out what it meant. And so this is helpful. So in the definition, you were talking about common law, and it's my understanding that when it's referring to maxims, that's referring to, that's part of the common law. Am I correct in that understanding?
Well, point of clarity is that I didn't bring up Black's Law dictionary at all. I don't believe I said that anywhere in my statement. But I'm familiar with Black's Law, and I don't have the definition written in front of me, so
Maybe it was
I
Mr.
think
Noes.
he
Okay,
mentioned Black's Law. I mean, look, many things that I have
Gotcha.
here are supported in Black's Law.
sure. Okay.
So what, I'm sorry, what's your question?
I was just wanted some understanding of what maxims are exactly. I know what they are.
Yeah.
So they're basically the law that guides law, right? They're the fundamental principles that underpin this legal system. Would that be correct?
Yes. They're the foundational principles of all law across the nation.
Okay. And so does common law include, it includes those, and then, and case precedent though, right?
No, no. If you read the definition carefully, case precedent is exactly precluded from the definition.
Any
You do
further
have to read it very carefully. It's a tricky sentence, and I know that attorneys will read the first half of the sentence and tell you that case precedent is part of the common law. But if you read the whole sentence, it's very clear that it is not.
Okay.
And I'm happy to provide written testimony to support that statement.
So as far as DCYF and family court goes, do you know if those courts move under that, if that's how they operate?
As legislative tribunals, that's how they operate.
Okay.
They do not have a magistrate that is independent of the proceeding, and they are often sealed, right? What were the 5 points that I made?
Well, I mean, not just inside DCYF, but the family court has judges, and it has rules in place to protect due process. Although we're hearing that there might be some places where those can be fixed. So can you just help me understand how, I mean, is it a problem not only within DCYF itself, or is it also an issue with how cases are handled within the family court that handles those DCYF
I'm not here to
cases?
speak to family court. I'm
Okay.
here to tell you what due process is through the lens of the Constitution at the
Okay.
time that it was written, and what a court of record is versus what a court not of record is. And if you're going to take rights away from people, it has to be in a court of record. And the DCYF court is not a court of record.
That's very helpful. Thank you for that clarification. Representative Kofalt.
Thank you, Madam Chair, and thank you for taking my question. So one of your statements about courts of record was that a court of record is to render decisions based, and I believe that the exact quote was based on common law, not on statute or precedent. Hopefully I'm close, if not spot on. Can you clarify the not on statute part? Because that one is a little bit confusing to me. Is it common law supersedes statute, or is it not on statute, as you sort of, should I take your statement literally?
I don't want to misspeak. Could you rephrase the question for me?
Sure. So a court of record is to follow the Constitution and common law. I'm with you up to that point. I also understand what you've presented in terms of precedent, and I will go look at that for myself to understand it better. It's that you said not on statute or precedent. I think I'm misinterpreting what you said, because to me that sounds like you're saying that courts of record should not consider statute in rendering their decisions at all. Did I misunderstand that?
I'm not going to comment, only because I don't want to misspeak.
Any further questions? Thank you for your testimony.
Thank you.
Appreciate it. And our last witness of the day, unless I missed anyone, I only have one card here. Okay. Betty Gay, the Honorable Betty Gay from Salem. Thank you. Would you raise your right hand? Do you swear the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth? Thank you. Thank you.
My testimony today is on behalf of Diane Cody, who 3 of us who are still in the room heard give testimony to a bill that directly affected her case. And she lives in Illinois, and that's why she's not here testifying on her own behalf. Her great niece, Adalyn Jeremiah, died of acute fentanyl poisoning in November of 2020. Her parents were doing drugs. She was left alone in the car with her older sister, and she ingested it and died. Family members had made multiple calls to DCYF because they were aware that the parents were doing drugs. DCYF, over several months, refused to intervene, so her name was already known to them. When she found out a few months later, when Adeline's mother, who was her niece, contacted her and said, "I'm pregnant," she had kept it a secret, and she asked her aunt if she would take care of her two children. She found that, so it wasn't until I received a call in January that she had given birth to a boy, asked her if she would raise him. So it was 10 days after his birth when she was called. She responded automatically that she would. So she had told DCYF, the mother had told DCYF who she had asked and given them her name, but DCYF never ever called Diane. Their DCYF policy manual, 1,600 placement considerations, would have directed them to try to place him with a family member. But when she contacted them, I'm trying to paraphrase this and not doing a very good job. The day after she learned the baby was born, Diane stated she'd be there in 24 hours. She has her own business as a real estate person. He was not out of care of his mother at the time, so she was traveling from Illinois. They asked me personal questions about my background and criminal history. She gave them everything so they could do a criminal check. They never responded to her. She made multiple calls to reach them, and when she finally did, DCYF informed her she was not an option because she didn't live in New Hampshire. And if I relocated to New Hampshire, they would engage me in the placement process. So she did. In my opinion, that's a pretty massive move and shows great intent to take care of the kids. Diane hired an attorney and filed for guardianship. DCYF informed her that she could not file for guardianship as they had him in their custody, and under RSA 169C, guardianship was not an option. But RSA 169C defines custody and guardianship separately, which we had to argue in court against DCYF, and unfortunately the Supreme Court gave them the argument that guardianship can coexist alongside DCYF custody. During the time when Diane initially contacted DCYF and told them she was ready, willing, and able to care for him, and a month before the Supreme Court went, I was living in New Hampshire, jumping through the hoops and obstacles that DCYF put in my path. They were not allowing policies. I was asking for explanations. Those are her words. DCYF limited my visitation with my great-nephew and niece with no basis. I went through the home study process for both children, but she knew they wouldn't place them with her because she was already fighting with them in court for guardianship. So she asked for an appeal of their placement decision. CASA was involved. CASA never spoke to Diane once during the entire process. It's supposed to be an independent party to advocate for children, but CASA didn't follow their policies either, one of which is to get to know all family members who have been involved in the children's lives. She gave the Office of Child Advocate to involve themselves multiple times during the DCYF's retaliatory and punishing behavior toward me. The OCA had to intervene on my behalf more than once. Diane is still in litigation, and that's why I'm trying to be very careful to follow only what she has told me because they are still in litigation. DCYF is still fighting Diane every chance. They didn't like that I won. I'll read from her words. They didn't like that I won at the Supreme Court. Then, the reason we, three of us, heard her testimony was because she became aware that a provision was put inside a 22-page legislative bill that would prevent anyone from obtaining guardianship over a child in DCYF custody. Fortunately, she heard about it. She flew here. She testified late one afternoon and was told she had 2 minutes. She luckily did talk more than 2 minutes. She says she has been dumbfounded by the lengths and the money DCYF has spent fighting her instead of working with her. She couldn't understand why they wouldn't want the assistance of a non-criminal, well-established, caring family member who their mother expressly asked to care for her children. But then she learned more about child protection services as she got intimately involved. Because of the cloak of invisibility, all the protective services, which is an amalgamation of many services, not one nice, clean organization, because of the cloak of invisibility they have over them, the guise of protecting the privacy of children in abuse and neglect. The law makes it unlawful for citizens involved to speak out to anyone regarding details and facts of what has occurred in their family through the courts and DCYF because they're threatened with fear and jail time and not seeing the kids. I'll add that. They use it to their advantage to block everyone from information, making it inaccessible under the cloak of privacy. She's also learned there's a complex web of funding from federal, state, and local sources, leaving it accountable to a hodgepodge of authorities. Although the agencies are usually called Child Protection Services, state and local agencies are only linked by a loose set of federal guidelines that provide broad definitions for child maltreatment, along with the Act ASFA, which is Adoption and Safe Families Act. It was enacted in 1997 under the Clinton administration. It's undergone several rewrites, but its overarching purpose has remained steady to ensure, quote, timely permanency planning for children. But part of the emphasis on permanency includes financial reimbursements for foster care programs. This starts with Federal Foster Care Program Title 4E of Social Security Act, which functions as an open-minded, limitless entitlement grant. There's no limit to the amount of funding that can be provided for eligible foster children each year. States receive reimbursements ranging from 50 cents to approximately 76 cents for every dollar spent on daily child care and supervision, administrative costs, training, recruitment, and data collection. And this she took from Elizabeth Brico's source, talkpoverty.org. In Diane's opinion, DHHS and DCYF do not make decisions based on what's best for the children. They're making decisions on what's best for DHHS and the state of New Hampshire. They're incentivized to keep children in the system and use their programs. My great mother, Diane says, my great nephew had a mother who expressed her direction for him to be in my care days after his birth. Yet DCYF decided to go another route, put him in the system, a system he and his sister are still in 3 years later.
Thank you very much for the testimony on behalf of Ms. Cody, who couldn't be here. Any questions from the members of the committee? I have a question for you. I know that you've been an advocate for people dealing with these issues for a while. Are you aware, are there any, and I'm sure we'll have the department in here at some point to answer some questions too. Are you aware of training that goes on regarding due process within DCYF?
Well, I'm certainly not, and that's, that's not a statement that I know they don't get it.
Okay.
They certainly could.
Fair enough.
My concern that it makes me very sad that money talks so loud, because if we look at how much money the state receives from congressional acts, that might turn people against us, because they'll say, oh, we'll have to make up that many millions per year. Well, my argument is, if you could get children out of the system, you wouldn't be spending that much money. And, you know, it's a matter of what's right and wrong. So maybe it will cost us more if we stop getting it, but it's just like all the people that I'm aware of to receive, who are ordered to pay child support through the state. The state gets money from the federal government for processing child support. Then they turn around and charge the people paying child support a fee for doing them this service. So they have to hire people to process the child support, and they also then make mistakes and charge people with being delinquent, threaten them, and I know this for a fact. I've heard it directly from the people. They'll send threatening threats that they will be charged, for breaking the law, for being delinquent, and they aren't. So then the people have to go through missing work to set the record straight. So it's not just DCYF funding, it's also child support funding.
Thank you. Any
Thank
further
you.
questions from the committee? Seeing none.
And thank you so much for participating in this very valuable committee.
And we have one more witness, Victoria Peruse of Franklin, New Hampshire. Thank you for being here. Would you raise your right hand? Do you swear the testimony you will provide is going to be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
I wanted to clarify some things in regards to my husband's earlier testimony. There were some things that were not very clear, and I want to make it known that our family is a blended family of 5 children. 4 live with the other party full time. 1 is my child with my husband, and she lives with us full time. In regards to this alleged incident, there was only a safety plan made for 4 of the children. Where's the concern for my child? Where's the concern? If they believed that he did this, why only 4? Where's the safety plan for my child? That makes no sense to me. The only other testimony I have is in regards to the home visit. That is the only other time that I have ever had contact with the CPSW in question. She came into our home, had a walkthrough of our home, stated that she was very pleased with what she saw, asked us questions related to discipline and how we disciplined our children, and was very pleased to hear our answers. And then she turned to my husband and asked him, how could you have handled this incident differently? Basically claiming my husband guilty before even hearing him speak. I have an email chain with her where I provided her a link to evidence, photos, videos, text messages and a witness list of 2 other adults that were there that were never contacted. She responded to this email chain, confirming that she received the evidence and the email. So why, in the end, when we finally got our records that we requested, did she leave it out of her report? That makes no sense to me. And of course, there's going to be a preponderance of the evidence when you omit an entire side story. And that is all I have to say.
Thank you very much for sharing those additional details. Those are also very important. Any questions? I see one question, Representative Leon.
Thank you, Madam Chair. Thank you for sharing that. I just wanted to hit on your question about the parenting plan. Is that because there was any concerns with your shared child, or you're looking at this as a concern about how the DCYF is treating
I
these?
am merely trying to look from the outside in. If there are 5 children that my husband has parenting time with, one living with him full time, why are you excluding the one child that he would have the most access to from any safety plan? If you really believe that any allegation is true, why are you leaving a child in his presence?
Thank you.
All right, seeing no further questions, thank you very much for your testimony. Okay, I don't have any more cards here. Did you have something to add?
If you're all right with it, just because.
Can you step up to the microphone? And state your name again. And you're
Sorry
still
about
under oath.
Yes. Andrew Noes, just an earlier question that you had, Representative Cushman, just because it referred to one of the points that I made in my testimony. If you'd like, I think that if you wanted to restate that question and then to Representative Kofalt's question, I think just very, very quickly that can be addressed if you'd like that.
Which question?
So you asked about the aspect of common law and how that's going to apply to a court of record.
Okay.
And then Representative Kofalt had a question about the court's acknowledging statute. So,
Yes, if you have insight on that, go ahead.
yep. So as Dan referred to, the definition of common law can be confusing when it's defined by attorneys who often have ulterior motives, but it's actually pretty distinctly defined as being very, very different from and opposed to statutory law. So common law, and again, I'm just reading right from Black's here, is distinguished from law created by the enactment of legislatures. And so common law is that body of law, and you refer to the maxims, which has been preserved in antiquity. And what's particularly pertinent here is that body of law and the law common to all men that the founders were looking at when they wrote our Constitution. Which is why, and then again, going to what a constitutional right is, I referred to that earlier in my testimony. There can be no legislative interference with a constitutional right. I don't know if that answered everything to your point.
That it's very helpful. Definitely clarifying.
And then to Representative Kofalt's point, I don't know if you wanted to restate that question just to make sure that I get it correctly.
Thank you. So yeah, my question was really to the statement, to ask for a clarification of the statement that I was hearing. The statement that I was hearing was that courts of record render decisions, or should be rendering decisions, based on the Constitution and common law, and then as close as I can remember, not on statute or precedent. And I heard the justification for the precedent part. It sounded to me like that statement was excluding statute. Was it? And again, I'm asking you about somebody else's intent when they made the statement. What is your interpretation? Do courts of record to exclude statute, or are they to interpret things through the lens of first the Constitution, second common law, and then interpret statute and render decisions based on that?
Right. Yeah. So thank you for that. It's definitely the former. Because a court of record has to move under the common law, and a common law action is one which is governed by the common law rather than statutory, it must only be considering the common law and the Constitution in its judgments. And as that pertains to the question of due process and how that's applying to DCYF, statutes are most often referred to and utilized when taking these rights away. And to Dan's point earlier, if these hearings were in a court of record, in a true common law court of record, and the matters being heard before a jury of 12 of that person's peers, and they were not using statute which does not comport with the common law, right? Because this came after the Constitution was written, and the common law doctrines and theories which were used to establish these rights that we're talking about here and that we're considering as it pertains to due process came before. And again, referencing that decision out of California, there's a pretty narrow historical window we have to look at for what the intention was in our Constitution for due process. And that is what we look to the maxims and common law for, and as that applies to the Constitution. So again, in short, yes, a true court of record is not going to be utilizing statute, only common law, as it pertains to the rights of the people.
Any further questions? Seeing none, thank you again. And with that, we will, well, since everyone's gone, I guess we'll push off the discussion, and we'll take this subject matter up among the members of the committee during our next meeting. We're looking forward to March 25th. I also wanted to announce the email address for the committee for those who wish to send us something. Sorry, I had it up and now I can't find it. All right, it is House Special Committee on DCYF at leg, which leg.state.nh.us. So if you wish to submit testimony or additional documents, you can send them there for now until we have IT figure out the online submission form. All right, and with that, we'll close the hearing. Thank you.
You could say